Every day in the USA, people find themselves in court.
Tia Hall. All right. Are you Tia K. Hall?
No, I'm Theo Green.
Well, Theo Green, I don't have you on my list. Hold on 1 second.
It's a tip
Hold on 1 second.
for a tether. It's for tether violation. Tether violation.
Hey, Curry, did you guys talk to?
No, and we typically do not get violations in terms of information, like people we need to interview with once.
I'm usually so how many supposed to rinse are they on another violation? Attorney Scott, you know what? You know more than anybody.
He might be the better
this building.
Yeah, because I've never even had to do.
Hold on. Have a seat, Mr. Green. Let's figure it out for a second. All right, Dale. Do you know why I'm supposed to see Mr. Green or Mr. Jackson for that matter?
I don't know.
I mean, he's gonna get a bond. Mr. Green, you're gonna get a bond order for your tether violation. So will Mr. Jackson. Because they're tether violations, it will be no bond because it's tether violation, and then he'll get set for his next court date. But I don't think there's anything for me to arraign him on. Does everyone who has a law degree in the room agree?
I think you just said that we're hearing the judge.
Yeah.
I agree.
What we do on the weekends.
Agree? Okay. All right. And everybody who's involved in the law process agrees as well? Yes. Jail, yes. Okay. All right, Mr. Green, you're going to get a next court date. I might be able to give it to you right now.
It's on Your Honor. Is it I think it's the 28th. Tuesday.
Do we know what his next court date is?
I'm sorry, the 12th. Tuesday the 12th.
Okay, it's actually on August 26th at 8:30 a.m. in front of Judge Behe.
I have something else. Can I ask you about that? Tuesday the 12th is my exam.
They will, the jail, and the court staff and everybody will coordinate that for you.
Okay, so I'm to remain in jail until my court date?
Yeah, because tether violation, you're gonna have no bond. Okay?
Oh, really?
You'll be able to talk to your attorney about it.
And until the 28th, I have to be here till the 28th.
It's the 18 with Marable. Sorry.
Oh, jeez. All right, that was all wrong. I apologize. Your tether violation hearing is on August 18th at 8:30 a.m. with Judge Marable. And if you have an exam before that time, you might have that court date before that. So just talk to your attorney about it, okay?
So there's no bond at all?
No bond.
Wow.
Yeah. Tether violation, that's what happens. There also be no bond for Mr. Wayne Jackson, and you will get his next court dates as well. All right. So then it looks like the only two people I have left are Tia Paul and Aaron Snyder. All right. Are you Tia K. Howell?
Yes.
Okay. Let's see. I have 2 arraignment files, it looks like, for Miss Hall, and then I have 1 bench warrant. Attorney McCarty, just so you're aware, she had a felony file. It looks like she did not appear for her substance abuse screening or for her sentencing. Kind of an old case from 2023, but the bond on that is $5,000, 10%. Looks like.
Thank you, Judge.
All right, so hand that one back. Okay, and then I have 2 files here. I have 24A00743OM People of Flint Township versus TK Hall, 23A02002OM. People of Flint Township versus TK Hall. Attorney Clary, go ahead.
Erica Bakari on behalf of Ms. Hall, she has been advised of her rights as well as the charges and the maximum possible penalties. Pursuant to both misdemeanor complaints, we'd like the court to waive a formal reading of each and her pleas of not guilty and the matter set for pretrial. Ms. Hall is not employed. She is requesting court-appointed counsel and she qualifies.
All right, thank you. Ms. Hall, your attorney stated that they did go over these two cases with you, these two misdemeanor retail fraud charges, maximum possible penalties for those charges, as well as all of your rights. Do you need me to read any of that to you again?
No.
You know and you understand those things? Oh, I'm sorry, I couldn't hear you.
Yes, I do.
Okay, do you have any questions about them for me today?
No.
I'll waive the reading of the charges, maximum possible penalties for the charges, as well as Ms. Hall's rights. As both she and her attorney have indicated, she knows, she understands those things, and she does not need me to read them to her again today. We'll enter a not guilty plea on her behalf on both matters, set the matters for a pretrial hearing, and we will appoint, request, public defender's office to appoint counsel as requested. Attorney Bakari, I would normally be inclined to set a personal recognizance bond, but since she has a bond on the other file, what would you like me to do?
You would just like the court to set low cash bonds so she can obtain something.
Is there any way I can get a PR bond on the other one too, and then we can just have a PR bond for all of them?
Wouldn't that be nice? But no, because you have a history of not showing up to court. So that's not going to happen, Miss Hall. I'm going to make sure that you show up to court. Not to mention that the other bond is set by a different judge, and I'm not going to change their bond. That is their prerogative to do that. So in these two cases, there will be a $2,000 10% bond on each file. If you are released, Ms. Hall, you are not to use any alcohol, any recreational marijuana, or any illegal controlled substances. And you are not to possess or purchase any firearms or any other dangerous weapons or ammunition. All the other general bond conditions will be on your order. If you have any questions, you can ask your attorney about that. There will be a pretrial in both of these matters on August 14th. 2025 at 8:30 a.m. via Zoom with Judge Guidance. Anything else for Harry?
We are.
All right, Ms. Hall, you're all set. You go. And finally, we have Mr. Snyder. Is he feeling better?
He is. If you just, I just need 2 minutes to grab him.
Okay. Sure. You're walking while we're waiting.
Sneeze.
Bless you.
I couldn't just like.
Need all the help I can get.
I mean, bless you no matter what.
What?
Bless you.
Thank you. As I say, I need all that.
Right? 25T02204FY, people of the state of Michigan versus Charlie Dean Dillard.
Good morning, Bill. Sheriff Scott on behalf of Mr. Dillon, the sheriff here with me at the podium. Judge, she was in my office yesterday and I had an opportunity to go over the charges, the maximum possible penalty, as well as his right. And we would waive the reading of the complaint.
All right, thank you. Mr. Dillard, then you did go over this charge with Attorney Scott, the maximum possible penalty for this charge and all of your rights.
Yes, ma'am.
And you know and you understand those things?
Yes, ma'am.
Did you have any questions about those things for me today?
Oh, ma'am.
All right, I'll waive the reading of the charge, maximum possible penalty for the charge, as well as Mr. Dillard's rights. As both he and his attorney have indicated, he does know and understand those things and does not need me to read them to him again today. Well, they're not guilty plea on his behalf. We'll set this matter for a probable cause conference as well as a preliminary examination date. I will recall the bench warrant at this time. And Attorney Scott, what would you like to say in regards to bonds?
Judge, Mr. Dillon doesn't have the record. I believe that he has one misdemeanor. He found out about this warrant that was issued yesterday. He came to my office, but the problem was he came after 11 o'clock. So I told him to meet me here this morning in court, and he's here. And I also indicated to him, judges, that judges don't like people to wear shorts. So the next time he'll see you in court, he'll have one long pants.
Right. I'm a little more lenient about that than some other people, but it's very good advice. I do see a couple prior incidents. All right, and so I'm going to set a $10,000 personal recognizance bond. Mr. Dillard, while you're on bond with this court, you're not to use any alcohol, any recreational marijuana, or any illegal controlled substances. You are not to possess or purchase any firearms or any other dangerous weapons or ammunition. And all the other general bond conditions will be on your bond order. If you have any questions, you can ask Attorney Scott about that. And next court date, will be Property Cost Conference on August 21st, 2025 at 8:30 a.m. in front of Jess Crawford. The potential examination date would be August. Oh, sorry, I don't have that on here. August 26th, 2025. Again, in front of Judge Crawford. It looks like Circuit Court Judge is Judge Newblatt. Anything else, Attorney Scott?
No, yes.
All right, very good. Thank you. All right, so wait for your paperwork. I'll be all set.
Thanks.
Okay, sir, are you Aaron Michael Snyder?
Okay.
Okay, can you try to speak up for me a little bit?
Yeah.
There we go. Okay, are you feeling okay?
I've been better, but I'm not too bad.
Okay, all right, we'll try to get through this hearing, all right? It shouldn't take too long. 25T02-325FY, people of the state of Michigan versus Aaron Michael Snyder, Attorney Bakari.
Good morning, Your Honor. Erica Bakari on behalf of Mr. Snyder, Attorney Peter out advising of his rights, as well as the charges and the maximum possible penalties pursuant to the two-count felony complaint, and his right to have a probable cause conference and preliminary examination. With that being said, we'd like the court to waive a formal reading and are pleading not guilty on the matter set forth in PCC. Mr. Snyder is employed, however, he is requesting court-appointed counsel and he qualifies.
All right, Mr. Snyder, Attorney Bakari stated they did go over your charges with you, the maximum possible penalty for the charges, and all of your rights. Do you need me to read any of that to you again? I'm sorry, I couldn't hear you. Can you say it again? Hold on, our printer is running, so it's making it hard for me to hear you. Hold on 1 second. Okay, say that for me one more time.
Will you please?
Yes, I will. Count 1 is breaking and entering a building with intent. Says on or about August 6, 2025. Allegedly, you did break and enter a garage located at 935 Lincoln Avenue with the intent to commit crime of larceny therein, contrary to MCL 750.110. That's a felony punishable by up to 10 years in prison. Count 2 is burglars, tools, possession on or about August 6, 2025. You did knowingly possess pry bar, pipe cutter, adapted and designed for cutting or burning through, forcing or breaking open any building, room, vault, safe, or other depository, not including a motor vehicle, with the intent to use it to steal any money other than property, knowing the same to be adapted and designed for the purpose of cutting or burning through, forcing, breaking, opening any building, room, vault, safe, or other depository, not including a motor vehicle, with the intent to use or employ the same to steal, contrary to MCL 750.1161. It's also a felony punishable by up to 10 years in prison. Do you understand?
Yes. Yes, ma'am.
Okay. And do you understand your rights today?
Yes, ma'am.
You want me to read those to you again?
I don't think so.
You don't think so? Why don't I just go ahead and do it just to make sure? You do have the rights to remain silent. Anything you say orally or in writing can and will be used against you in court. You have the right to have a lawyer present during any questioning consented to, and to have a lawyer present during your court hearings and to represent you in this matter. If you do not have the money to hire a lawyer, we will ask the public defender's office to appoint you a lawyer to represent you. You have the right to have this matter set for a probable cause conference not less than 7 days or more than 14 days after the date of the arraignment, and set for a date for a preliminary examination not less than 5 days or more than 7 days after the date of the probable cause conference. You have the right for me to determine today what form of pretrial release, if any, is appropriate. You also have the right to a trial and to jury trial or bench trial and to subpoena witnesses and things of that nature. You'll be able to talk about all those rights when it comes to a trial after your arraignment date, further with your attorney and with the continuing judge. Do you understand your rights? Okay. All right. And then let's see. Attorney McCarty, you did request appointing counsel, correct?
Yes.
We will appoint counsel as requested or as public defender's office to do so. And in regards to bond, Attorney McCarty.
Mr. Snyder has no prior criminal history. He's been in the county jail for 3 days. His address is accurate. He has a valid driver's license. We're requesting his appropriate.
Okay, I do have the as prior criminal history. He's got some operating while intoxicated charges, misdemeanor domestic violence.
Those were not.
Ma'am.
Okay.
Those are my brother, ma'am.
And I don't know. I got him here for you.
No, that's Anthony Aaron. I'm Aaron Michael.
Okay. Well, you're gonna have to talk about that with somebody else because they actually have that both these people are you and they have an alias. But and just what I'm looking at. I'm not saying it's right. I'm just saying it's what I'm looking at.
I understand.
All right.
Excuse me, ma'am.
Yes.
Do I get to go home to my daughter today?
I'm not sure yet.
I'm sorry, I don't want to rush you. I miss her so much.
I don't think you should say anything else, Mr. Snyder. I think you're in a lot of pain right now because I think you're going through withdrawals, and that will definitely put you in a not feeling very good position. But it also puts me in a not feeling very good position because I'm worried about letting you out and you going back to using. If I were to think about letting you out, would you agree to go get substance abuse treatment?
Yes, ma'am, immediately.
Have you been anywhere? Is it okay, Attorney McCarty, that I'm asking these
Yes,
questions?
of course.
Is it okay to, I mean, have you been anywhere for substance abuse treatment prior to today?
A long time ago. It was a pony show. Ma'am, it was a pony show for my family. I didn't have a daughter or nothing. I didn't have a family. Things are way different now. I honestly, I promise you.
It's not. Hold on. Stop talking, Mr. Snyder, before you say something that you shouldn't say. It's not any different because you're going through withdrawals right now, sitting in the county jail. So apparently it doesn't matter that you have a daughter or not. You're still using. It's the problem. And I wouldn't be irresponsible if I were just to let you out and say that you can just go back to your daughter in the state that you're in. So I'm considering letting you out, but you have got to get treatment. You understand?
Yes, yes, ma'am.
Right,
No,
say
no.
anything else. Don't say anything else.
Okay.
There are the two charges. I'm going to set a $10,000 personal recognizance bond as to each count. Mr. Snyder is to be placed on GPS tether because I am worried that he might get out and not do what I'm asking him to do. So you are released on GPS tether with a curfew as set by the tether unit. You are not to use any alcohol, any recreational marijuana, or any illegal controlled substances. I want you to check in with the pretrial services department so they can make sure you are doing what I'm telling you you need to do. You are to submit to random weekly drug and alcohol screens to ensure that you're not using anything you're not supposed to be. And I want you to, within 24 hours of being released, I want you to do an intake appointment at Flint Odyssey House, and I want you to follow all of their recommendations. If their recommendations are for you to go to inpatient, you're going to inpatient. If the recommendations for outpatient, that's fine too. But you tell them the truth about your use, and you are to follow their recommendations. It's the only way I'm letting you out of jail. Do you understand?
Yes, ma'am. Thank you so much. I've been needing this for so long.
All right, I agree. Okay. And let's see, what else here? All the other general bond conditions will be on the bond order. If you have any questions about those, you can ask your attorney. You have a probable cause conference on August 21st, 2025 at 8:30 a.m. Preliminary examination date is set for August 26th, 2025. Those are both in front of Judge Marsh. Circuit Court Judge is Judge Lichana. Mr. Snyder, this is going to be a test for you to see that if you can do treatment, you can make it out without using. You understand? Because if you go back to using while you're on bond, you're just going to end up right back in jail.
Yes, ma'am.
Okay.
Thank you.
All right.
Yes,
Okay. Yep, you're all set. Then you can go.
Okay, I've been needing this for so long. Thank you, ma'am.
All right. You are welcome. Good luck.
Is my paper here?
I'm not sure if that's paperwork or not. The jail will let you know. But you're free to go. You're welcome. Okay. I think that's it, jail. Thank you very much. What do we got next?
I believe that's it.
All right, thank you.